I'll just go ahead and go through it again for the record. In case number 22 CR 12, Ms. Emery was indicted for aggravated possession of methamphetamine, a 5th degree felony, and I understand you've been aware of this indictment, Mr. Parker. Have you previously received a copy of this before today?
22 CR 12, yes, Your Honor.
Okay. All right, and does your client waive reading the indictment?
She does, Your Honor.
All right. It is a 5th degree felony. All right. And how does she plead?
Not guilty, Your Honor.
All right. And I say you're in Batavia?
Yes, sir. Well, Amelia, Your Honor.
Or Amelia, I'm sorry, Amelia. With Mr. Rack?
Yes, sir.
Okay. All right. Then in case number 22 CR 43, she was indicted for 3 counts of aggravated trafficking of methamphetamine, 3 counts of aggravated possession of methamphetamine, and a forfeiture. And one of those counts, count 3, is a vicinity school zone 1st degree felony. Counts 1, 2, and 4 are 2nd degree felonies, and then 5 and 6 are 3rd degree felonies, and the forfeiture specification seeking for a vehicle. Now, your client turned herself in on that guess this morning, and you're aware of that charge then?
Your Honor, we suspect additional charges. I inquired with the prosecutor's office that Ms. Henry was perhaps on the secret night, and they were very forthcoming with information that basically backed herself into the drug company. So I was aware there was likely another case. This is my first time hearing of the charge.
Okay, you want me to read the indictment then, or?
No, Your Honor, I can go for that with Ms. Henry. We could waive the reading.
And do you, since she, and in both of these cases, since she's only had her indictment since this morning when was served on her, you waited 24-hour waiting period as well?
Yeah.
Right.
Yes, sir.
And she enters plea of not guilty?
Yes, sir.
All right. And she pleads not guilty in 22 CR 43 as well?
Yes, sir.
All right. All right, now, I have tentative pretrial set for March the 16th at 2 o'clock. Be by Zoom, Mr. Parker, if you're available. We could do it a little earlier or a little later. And,
2 p.m. on the 16th will be fine, Your Honor.
all right. We'll set the pretrial in both cases for that day. And then final pretrial April 13 in both cases.
Yes, Your Honor, I can make it 13.
2 o'clock. All right. And then I'll set these together for trial, although I'm not sure that can be done, but at least for purposes of scheduling at this point, we'll set both for the same day. And I have April 28th at 8 a.m.
Yes, Your Honor, I can make that as well.
All right. All right, now, I wish to speak to the matter of bond, Mr. Parker.
Yes, Your Honor, I would. Thank you. I asked you to consider the OR bond. You understand there are serious charges. I would note, I believe some of these charges reignited from a case between the CR 100, which the state originally voluntarily dismissed. On 7/8/21, Ms. Henry did post a $50,000 surety. So she's already out those funds from the previous case, obviously. We asked her to consider OR. She's turned herself in. Ms. Henry and I spoke. She knew that she likely had guilty charges on felony charge, and in spite of that, she still voluntarily surrendered herself in this case. So I asked her to take that into consideration.
All right, I see that the assistant prosecutor came name is swallowed again. Ms. Henry's waived reading and entered plea not guilty in each case, Mr. King. Now, going to the matter of bond, is the 22 CR 12 the case that was re-indicted? Is that the one you're talking about?
I believe it's 22 CR 43 maybe.
Oh.
The case was the charges reindicted.
Not only was it reindicted, Your Honor, but there are also some additional charges that were prepared.
All right. And that previous case was dismissed.
Correct, that's right.
And she had a bond in that case, you said, Mr. Parker?
Did, Your Honor, she had a $50,000 bond that she posted on July 8th.
Last year?
Yes, Your Honor.
Okay. All right. So these charges allegedly happened. Well, which ones are the new charges in the 43 case, Mr. King?
The new charges would be most recent at times.
5 and 6.
Yes.
All right. Well, I know that those are the lesser offenses. I think those are the third-degree felonies. I know the counts 1, 4, I believe, carry. I know they're alternate counts in 1, 2, 3, 4, but they carry, I believe, mandatory time. So what I'm going to do, I'm going to set the bond in that case the amount of $25,000 plus OR. And on the aggravated possession charge, 12, I'll set that as an OR only. The defendant will be required to pay service fees of $160 in each case, a deposit, I should say, service fees prior to release. And if she makes bond, then she will be under pretrial supervision of under the probation department, 117 East Main Street. She'd report there immediately upon release if she makes bond, and then report once a week, 4 weeks after that is determined by the department under the random web testing by co-workers from home self-employer. Recommend by probation to evaluate substance abuse, mental health issues, and treatments indicated role in the fall under independence action, and be under house arrest for residence of 1080 Old State Road, Wilmington, Ohio, which means that she'll have to be there unless she's working or to and from work, medical appointments, court proceedings in this or other cases, appointments with an attorney, probation officer in this or any other case, attending kind of school, educational programming, church services. Other than that, she must be there all the time. All right. Anything further than from counsel?
No, Your Honor.
All right, thank you. All right. Let's see, Butler's coming in from jail.
Yep, JD's there as well, Judge.
Okay. My cousin and counsel already, I have, over there, okay. But who's his attorney?
JD.
JD, I think he's gonna be there, I think they're
Yep.
there. Yeah. There's 2 cases on Mr. Butler. Okay. All right. Yep, please. Yes, absolutely. All right, we have 2 cases before the court, both involving the same defendant. State of Ohio versus Cody Butler, case number 21 CR 187 and 21 CR 204. This hearing is being conducted by Zoom. Defendant is appearing from the jail by Zoom along with his attorney Jacob Wagner, and the state is represented by Assistant Prosecutor King. Mr. Wagner, you and your client both agree to presence in the courtroom and have this conducted remotely. That's all right with you, Mr. Butler?
Yes.
All right. Now, the defendant is indicted in 21 CR 187 for trespass the habitation when the person is present or likely to be present, a 4-3 felony. Then in case number 21 CR 204, he is indicted with for felonious assault and deceiving stolen property, second and 4-3 felony. And I believe we have the matter set for trial in March. Now, I've been presented with plea of guilty forms. I believe that's why this case was set for hearing today. And in each of these cases, Mr. Butler, I have been presented with a form. These are 3-page forms, I believe, in each case. Actually, the 204 case runs into a 4th page, which is the entry. And so I'm going to hold these up to you in case number 21 CR 187 is a plea of guilty, or it says you're going to plead guilty to the charge on page 1. Do you recognize that agreement I'm holding up there, the first page?
Yes, sir.
Okay, now I'll turn this to page 3, and there's about not quite halfway down, there's a sentence that says, I enter this plea voluntarily. Below that, there's a blank line with signature dependent printed below that, and there's a little X over there. And I'm going to hold this up to the camera and ask you if that is your signature there next to my finger,
Yes, sir.
where it says, I enter this plea voluntarily.
Yes, sir.
All right. Now, in case number 21 CR 204, it says you're going to plead guilty to an amended charge of attempted felonious assault, count 1 and count 2. I'll hold the first page of that up to the camera and ask you if you recognize that agreement.
Yes.
Okay. Yes. And on page 3 on this one, about halfway down, there's again a statement that says I enter this plea voluntarily with the signature line below it. And I'll hold the camera, hold that up to the camera. Is that your signature there below that sentence?
Yes, sir.
Okay. When did you sign these agreements, Mr. Butler?
I believe it was Friday. Friday.
There at the jail?
Yes, sir.
And was Mr. Wagner there to go over that with you in each case and explain them to you and answer any questions?
Yes, they did.
And when you signed these documents, did you understand that they were agreements to plead guilty, which means it wouldn't be a trial? In either case, the next step in each case would be a sentencing hearing.
Yes, sir.
Did you have enough time to fully consider the matter before making the decision to sign these agreements?
Yes, sir.
And you still wish to go forward with these agreements after you've had the weekend to think about it?
Yes, sir.
And did you enter into these agreements voluntarily?
Yes, sir.
All right. Now, the agreement on page 1 in the first case, 21 CR 187, states you're going to withdraw your not guilty plea guilty to the charge in the indictment of trespass and habitation when a person is present or likely to be present. The violation of section 2911.12b, Ohio Revised Code 4-3 felony. It further states that you understand the maximum prison term for that could be 18 months. The minimum would be 6 months if the prison term is imposed. There could be a fine of up to $5,000. You understand that?
Yes, sir.
Case number 21 CR 204, it states you're going to plead guilty to attempted felonious assault on count 1. And under the law, the felonious assault charge is 2903.11A2. Attempt under the law is an included or lesser offense that if the evidence warrants, instead of being found guilty of the original charge, a person will be found guilty of the lesser charge. And that's 2302A is what that law says. So that's why they're both on that line. And that would make that a third-degree felony. Currently, you're charged with a second-degree felony, which has a possible prison term between 3 and 8 years as a minimum and a maximum of 50% more that would be added by the Department of Corrections, depending upon their determination. Whereas the attempted felonious assault is a third-degree felony, which would carry a prison term between it's not a high tier, Mr. King, it's a low tier.
It's it's
Yeah, because it's not
minus
mentioned.
36.
Yeah, okay, all right. So that means the prison term is between 9 and 36 months. It's a maximum. And then it starts at 9 or certain levels in between. And you find $10,000 on that charge. Count 2 receiving stolen property in 2913.51. Fourth degree felony says you understand the maximum prison term for that could be 18 months, minimum would be 6, and fine could be available $5,000. You understand that?
Yes, sir.
Under the law, if you're convicted of all these offenses, Mr. Butler, the court could order you to serve the sentences consecutively in prison, which means, and could also total up the fines. So that means that the total possible prison time, you have 18 months at 187, another 18 months for count 2 and 204, and that's 36, plus 36 months on count 1. So that means you have a potential maximum prison term of 72 months, and a maximum possible fine of $20,000. You understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on community control, probation, parole, or post-release control for a felony?
Yes, sir. I'm not even on probation for this meeting.
All right. Now, under the law, if you're convicted of these offenses in the first count of the case number 21 CR 204, that would be considered an offense of violence, and because of that, on completion of the prison term, you would be put under post-release control supervision under terms set by the adult parole authority, since the court has nothing to do with that. And that means you'd be supervised by a parole officer in the terms that they have set forth. That would be for at least 1 year, and it could be up to 3 years as determined by the APA. Now, if in case number 187, in that case it's optional, and in that case it could be up to 2 years, it's optional, but because it's mandatory in the 204 case, we know that it will happen. On count 2, receiving stolen property is also optional. Now, if they determine while you're under post-release control supervision that you have failed to comply with those conditions, then they have the right to return you to prison, to make you serve an additional period of up to 9 months for any one violation, but there's a cap or limit of half of whatever prison term was imposed by the court for all violations. However, if you commit a new felony while you're under post-release control supervision, then in addition to whatever sentence could be imposed by the judge in that new case, that judge could also sentence you for committing that felony offense while under post-release control in these cases to an additional period of 1 year, or whatever time is left on that 3 years of in 1 to 3 in the count 1, and then the other one would be 2 of the others. Whatever time was left, or 1 year, whichever is more, would be imposed. That would have to be served consecutively to the sentence in that new offense. Do you understand that?
Yes, sir, we do.
Now, under the law, none of these offenses, I should say, in either case, are mandatory prison term. The court could grant community control in either of both cases. Community control is what most people know to be probation. That means that instead of going to prison, you'd be put under the supervision of a probation officer, county probation department, under terms set by the court. Now, if during that period, that could be for up to 5 years, and if during that period of time the probation department felt that you were not compliant, they would file a written allegation back to the court, would be served a copy. Then there would be a hearing, and it would be entitled to have an attorney to be represented at that hearing. If the outcome of the hearing was that you had failed to comply, then at that time the court would revoke your community control in each case and sentence you to a total of 54 months, fine you $15,000 in 21 CR 204, and 18 months and $5,000 in the 187 case consecutively, for a total of 72 months and $20,000. You understand that?
Yes, sir, I do.
Right now, in case number 21 CR 187, the indictment alleges on or about October 19, 2021, Highland County, Ohio, you did by force, stealth, deception, knowingly trespass in permanent or temporary habitation of Robert Neal or any person other than an accomplice of the offender is present or likely to be present. Violation section 2911.12. The Ohio Laws Code, again, that's the trespass and habitation. One person is present or likely to be present, a 4th degree felony. In case number 21 CR 204, count 1 alleges as amended to the attempt to read that on or about December 1, 20, well, let me read you the way it reads now. Count 1 currently reads, on or about December 1, 2021, in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to Doug Peterson by means of a deadly weapon or dangerous ordinance, to wit, Glock 42 handgun, deadly weapon, as defined in ORC section 2923.11a, in violation of 2923.11a2. So that's the charge of one's assault secondary felony in this charge. Now, the state is amending, and the defense is agreeing to that amendment, Mr. Wagner.
Yes, sir.
All right, so the state would be amending that charge to read that on or about December 1, 2020, Huntington County, Ohio, that you did knowingly and or purposely engage in conduct which, if successful, would have resulted in or constituted the offense that's outlined in count 1 that I just read to you. And that reduces that then to a third degree felony as opposed to the current second degree felony. Now, count 2, it alleges that on or about December 1, 2021, Huntington County, Ohio, you did receive, retain, or dispose of certain property being a Glock 42, a firearms defined in ORC section 2923.11, property of another vehicle code, and that you knew or had reasonable cause to believe it had been obtained for some theft offense, a violation of section 2913.51. So that's the charge received stolen property, also a fourth degree felony, the same penalty as the charge in 21 CR 187. All right, now, Mr. Butler, do you understand what it is you've been charged with in those offenses by the state? What the state has said you did, when, where, and how they allege you did it?
Yes, sir.
You understand the penalties for each of these 3 offenses? All right? Now, you discussed the nature of the charges, the evidence in the cases in each case, possible legal issues in each case, possible defenses you might try to raise in a trial in each case, and the possible outcomes of the trial in each case with your attorney.
Yes, sir, I did.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any type of drugs or alcohol at this time?
Yes.
Are you taking any prescription medications there at the jail?
Yes, sir, I am.
And what are they for?
I got a large knot on my side that's been causing me issues.
Okay, so it's a medical issue, not a.
Yeah, no, psychological.
And does that medication cause you to have any problems understanding or comprehending what's going on?
No.
All right. Now, have any threats been made against you to plead guilty here today?
No.
All right, now on page 2 of each case charge or each agreement, there's several sentences that are printed in bold and underlined. So I'll read the first one, 21 CR 187. Those lines read as follows. Defendant shall enter plead guilty to the indictment, state defense, jointly recommend 12 months incarceration. Second, the sentence above the case number 21 CR 204, defendant agrees to make full restitution. And do we know what that amount of restitution is, Mr. King?
No restitution, Your Honor.
Okay. Case number 21 CR 204, the underline in bold printing reads as follows. Defendant shall enter plead guilty to count 1 as amended, count 2. State defense jointly recommend 24 months incarceration on count 1, the second 12 months incarceration on count 2. Be served and secondly the sentence imposed in case number 21 CR 187. Defendant agrees to make full restitution. Is there any restitution in that case?
No, Your Honor.
All right. Now, you understand that agreement?
Yes, sir.
Does anyone promise you anything other than what I just read to you in these 2 agreements to get you to plead guilty here today?
That's,
Right, now, under the law, Mr. Butler, the matter sentence is up to the judge, not the parties. So even though there's an agreement as to what the sentence should be in these 2 cases between the parties, and if you plead guilty, I'm not required to follow that agreement. I could, after I considered all the evidence, decide that's not the appropriate sentence and it should be something different, more or even less, anywhere from 6 months to 2 months. You understand that?
yes, sir.
Or actually 9 months would be the minimum one, but third degree. Now, you hold any license or certification from any state agency that regulates any trade or profession? Governmental agency, not a trade group.
No, not governmental. I'm HVAC certified.
Okay, yeah, correct. All right. Now you have certain constitutional rights, you must understand, before I can accept your plea of guilty in these cases, Mr. Butler. First of all, you are have a right to have a jury trial in each of these two cases. And what that means is that there would be a jury of 12 persons selected in each case from a group of citizens that reside in Hyde County that are summoned for jury duty on your trial date in that particular case. Once 12 people are selected, the evidence will be presented, then they will be instructed on the law. And in each case, the jury in that particular case would have to find unanimously, meaning all 12 would have to agree, as to whether or not the state proves your guilt on those charges in each case. Now, if you did not want to have jury trial, but you did not want to plead guilty in either case, then you could waive the right to give up in that particular case your right to have a jury trial, and then in that case you have what's called a court or bench trial. So that means that instead of a jury hearing the evidence in that particular case, it would be the judge who would hear the evidence, and the judge would apply the law. The judge would be the one who would decide whether or not the state proved your guilt in that particular case, by proof beyond reasonable doubt. You understand that?
Yes.
All right, now, under the Constitution, you have a right to confront the witnesses against you in each of these cases and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of that would be to bring out evidence to help your side of the case. You understand that?
Yes.
Now, under the Constitution, in each of these cases, you have the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So, if you are not certain that witnesses that you have are going to come in voluntarily at your request, the court would issue a subpoena, which is a court order in each case, that would require those persons that you want to testify to come to court and be available to testify if you want them to, even though they don't want to be here. And that's the same way the state's witnesses would be required to come to court to testify against you in each of the cases. You understand that?
Yes.
Now, in each of these cases, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence or testify in either case at any time by anyone. So, the prosecutor can't make you testify, the judge can't make you testify. It's your decision. If you decide not to testify, the fact that you did not testify, not be used against you in any way by any person, no one can even comment about it except in one situation. That is, if there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that? Right now, under the Constitution, you're presumed innocent in each of these cases until proven guilty by the state of Ohio, every essential element of each offense, but beyond reasonable doubt. So what that means is that the burden isn't on you to try to prove that you're not guilty of either of these, of any of these charges in either case. In fact, under the law, you're not required to present any evidence in your defense in either case. You could, but you don't have to. But whether you present any evidence of your own defense in either of these cases or not, the burden will remain upon the state in each case to prove your guilt of all the essential elements of the charge or charges in that particular case by proof beyond reasonable doubt. That's the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, Mr. Butler originally entered a plea of not guilty to these charges in each case. That plea denied the allegation, denied you committed any crime, and exercised or invoked all the rights I just described. Change your plea from not guilty to guilty to these two cases, as set forth in the agreements, then that would be the plea doctrine, not guilty plea. Guilty plea admits the allegations in each of the charges. The two in count, in 21 CR 2 and 4 in the same count 187, 21 CR 187. It would admit that they are a crime as alleged, and that you're the person who committed the crime. And that plea waive or give up all of the rights that I've just described for you today, except the right to have an attorney. You always have a right to have counsel no matter what you plead. With that exception, plea of guilty, waive or give up your right to have a jury before trial. In both cases, you would waive or give up your right confront the witnesses in each case and cross-examine them through your attorney. In each case, it would waive or give up your right to use the power of the court to compel the witnesses to come to court to testify for you, just like the state in that particular case. In each case, it would waive or give up your privilege against self-incrimination because you're saying you're guilty, and that would be used to find you guilty in each case. In each case, it would waive or give up your presumption of innocence because if you plead guilty to the charge or charges in in each case, then the state doesn't have to prove it. Now, a plea of guilty also subjects you to being sentenced immediately by the court, which I believe is what's being proposed here, and waives gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I were to sentence you to the maximum sentence on any of these charges under certain limited circumstances, you can file an appeal. It would have to be filed within 30 days of the sentencing entry being filed. Now, do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Right now, Mr. Butler, do you have any questions about the charge or charges in either of the cases?
No, sir.
You understand them?
Yes, sir.
Any questions about the penalties?
No.
You understand them?
Yes, sir.
Any questions about the plea agreement in either case?
No, sir.
You understand them?
Yes, sir.
And do you have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
Yes, sir, I do.
Do you have any questions about the plea of guilty, what it means, or what will happen if you have that plea in these cases here today?
No, sir.
You understand that?
Yes, sir.
Do you have any anything that you'd like to speak with your attorney about before we're going?
No, sir.
You understand? You have any questions about anything that I've explained for you this afternoon?
No, sir.
And let's see, are you a U.S. citizen?
Yes, sir.
Okay, I think I asked you that, but I just want to be sure. All right, now, is it your decision then, Mr. Butler, to withdraw your not guilty plea in these two cases, and plead guilty according to the terms of the plea agreement in each case that I just gone over with?
Yes, sir.
Then in count 1 of 21 CR 187, which alleges an honor about October 19, 2021 in Highland County, Ohio, you did by force, stealth, and deception, knowingly trespass at a permanent or temporary habitation of Robert Deal, or any person other than an accomplice of the offender was present, like to be present, violation. Section 2911.12b of the Ohio Revised Code, the charge of trespass and habitation for a person is present or likely to be present. Under 2911.12b of the Ohio Revised Code, a fourth degree felony, carrying possible prison term between 6 and 18 months and a fine of $5,000. How do you plead?
Guilty, Your Honor.
All right, and count 1 as amended. If you agree that on or about December 1, 2021 in Highland County, Ohio, you knowingly and or purposely engage in conduct which is successful or constituted or resulted in the offense of causing or attempting to cause physical harm to Doug Peterson by means of a deadly weapon or dangerous ordinance, to wit, Glock 42 handgun. Deadly weapons defined under ORC 2923.11a of the Ohio Revised Code. A violation of section 2923.11a2 of the Ohio Revised Code, charge of attempted felonious assault, third degree felony, carrying possible prison term between 9 and 36 months in increments provided by law. Any fine of $10,000. How do you plead?
Guilty, Your Honor.
In count 2, that alleges on or about December 1, 2021 in Highland County, Ohio, you did receive, retain, and dispose of certain property being a Glock 42, a firearm is defined in ORC section 2923.11, the property of another Daniel Cope, that you knew or had reasonable cause to believe that obtained commission theft offense in violation of section 2913.51 of the Ohio Revised Code, charge of receiving stolen property, fourth degree felony. How do you plead?
Your Honor, if I may, was that charge being dismissed? Was it the plea on the attempted, or was it? I know we had an agreement for.
You know, the felonious assault was reduced to attempt, and count 2 was the plea.
Correct. So,
Correct.
is it correct? I know we had a second year item before, right?
What now?
Between the two cases, that's the, yes.
Okay, as long as the years added up correctly. Yes. I'm sorry, Your Honor.
Okay. All right, so how do you plead to count 2?
Guilty, Your Honor.
All right, thanks. All right, the court finds then on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. The plea is accepted and ordered filed. Defendant is found guilty in case number 21 CR 187, count 1 as charged therein. He is found guilty in case number 21 CR 204 in count 1 of attempted felonious assault, a third degree felony, and receiving stolen property, a second degree felony. pleas are accepted and ordered filed in each case. All right. Now, in as much as there's a agreed recommended sentence, and I did scan through the discovery very quickly while I was going through that and see that the defendant has a somewhat extensive criminal history. And so based upon the, and the nature of the charges and such, the court will not order a pre-sentence investigation. I did forget to ask though, Mr. King, in each of these cases, did you consult with the victims and obtain their approval on these agreements?
The state has attempted to, however, 2 of these 3 victims have not been able to get in contact with their owner.
Okay. All right. Anything from the state regarding sentencing?
Only what's contained in the plea agreement, Your Honor.
All right.
If I may, for 1 second, Your Honor, a question for my client.
Yes.
Your Honor, I'm back, sir. I'm back.
Yeah, I heard you. I'm looking at the something here. All right, Mr. Wagner, go ahead.
On case 184, Your Honor, obviously I know anytime there's a case involving a trespass or a home habitation like this, the court does have concerns. Again, this was an court. I should try to get worked out in this court. The victim was having nothing of it. I think a little insight in court. I mean, he was found basically in a home. He got the wrong home, I think. Not to make a lot of a situation, I think he was eating a bag of chips in the kitchen. Basically just got the wrong residence, Your Honor. And there may have been some substance abuse involved there. But as far as the other one, case, Your Honor, again, that's why we didn't have a pause here as far as the victim and the felonious. Again, I know this is not about, there is a crime is a crime is a crime. It doesn't matter what type of person it is that was committed against. But I don't believe he was the most upstanding individual that will ever get citizen of the year. So I think this may have been, I'm not saying justified, but I do believe my client feel he was provoked in defending the honor of someone. This doesn't fit into the castle doctrine. But it was something that was not mentioned as a bystander not walking the dog. But with that being said, Your Honor, Cody's been more than cooperative with me. He's been very easy to deal with. It's just a matter of getting something to take care of as far as numbers wise. We guys, of course, go all with that.
All right, Mr. Butler, is there anything that you would like to say?
This whole deal, man, it's like, as far as my character goes, yeah, I don't find that. I'm not proud of it, but I don't find it. Basically, most of my character is trying to get the numbers. And on this one, man, like on this whole previous case, like, I'm not the one getting punished. Send me to prison. It's what it is. I understand. I can get it on like that myself. One is being punished on all this is real. My mom. She's 7 years old in the nursing home. I want to be able to see my mom alive before, you know. Only thing I can ask on the felonious is maybe you show a little mercy on me for doing something to unsavory person. You know, yeah, granted I took the law in my own hand, but I don't think there's a father on the planet that would have done what I did. That's all I can ask really is that maybe we show a little mercy, maybe not necessarily on me, but on my mom. That's all I got.
Okay.
Okay, what I'm looking at here is defendant 21 CR 187, it looks like he was arrested on October 19th and was in jail until released on a furlough on November 15th. And then rearrested on December the 1st when the new charge was filed in 204. Is that correct, Mr. Wagner?
Yeah, Your Honor, my client is indicating he was doing this.
This happened on November.
Yes.
All right. Well, so after you got out of the hospital, you did not return back to jail.
No, sir, I had a follow-up appointment for the 6th of December. I was recovering from surgery at my friend's house, but the illness all happened.
Okay. Well, I happen to be the judge who signed the furlough order in municipal court on the 15th. I'm talking now, you don't interrupt me. That was as a result of a phone conversation on the 14th with Lieutenant Brown, I believe. And I furloughed you at, it says 6:31 a.m. That's an interesting time. That must have been the time they noted on the log. And it said that upon your discharge from the hospital, you were reported immediately back to the jail. And I see nothing in the file that happened after that. Yeah, I see nothing that happened after that to allow you to go anywhere else back to the jail. So then, if you had done what you were required to do, then you wouldn't have picked up the charge on the 1st of December. 2 charges on the 1st of December. So, unfortunately, you didn't do what you were told, or you would have been here on the second case. And Mr. Butler, I'm offended by what you said. That don't show mercy on you, show on your mother because you don't, you want to keep her alive and so forth. Well, if you want to keep her alive, what were you doing after committing crimes? You can't keep her alive by committing a crime. And going into somebody's house and without permission, and somebody doesn't know you, and then while you're violating the judge's order to come back to jail on December the 1st, you get into another fracas with Peterson and end up getting this conviction there. And then plus, count 2, stealing the firearm. And, then trying to say, well, yeah, I hurt somebody, but, he's just, forgot what the term he used was, basically, he's not much of a person, and so I ought to show some mercy for you on that. I think it's disgraceful that you try to vote for mother, try to get a break for yourself. That's all you're doing. Don't give me any crap about this for her, because you're not taking care of her anyway. You're out committing crimes and using drugs. So, with regard to case number 21 CR 187, is the order of the court that you be sentenced to a term of 15 months at the Correctional Reception Center at Ohio. And on that charge, you were out from, or you get credit from the date of arrest, which was 10/19 until 11/15. So that would be 26 days. With regard to the case number 21 CR 204, it's ordered that you be sentenced to a term of 30 months. These sentences are, on that one you have 76 days of credits from December 1st until today. Now these sentences are ordered to be served consecutively.
If I may, on the 204 case, there's 2 counts.
Oh, okay, I'm sorry. That's right, there is, all right. So it'll be 30 months on count one and 18 months on count two. Thank you. I'm sorry, 12 months on count two. 12 months on count two. Now, those sentences are were to be served consecutively to each other. For this reason, the court finds that these offenses were committed as two separate courses of conduct. And the case, the crimes of 21 CR 204 were committed while the defendant was out on a furlough, which he was in violation of for not having returned back to jail. And that the harm caused to these three different victims is not such that one single sentence would actually reflect the seriousness of the crime, nor are the punishments disproportional to the harm involved. The court also finds that this defendant's criminal history is such that it's necessary to protect the public. And the comments that he made in his own allocution certainly don't reflect any remorse for what he's done, and just reemphasize the court's concern that he is a danger to the public. Now, it's ordered that the defendant, or upon completion of the prison term, Mr. Butler, in count one of 21 CR 204, upon completion of this prison term, she will be placed on post-release control for the offense for at least 1 year, and it could be up to 3 years. The other two, it would be optional. Now, what that means is you'll be supervised in the terms that they set, and during that period of time, at least 1 year or up to 3 years, as they determine. If you commit a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge could also sentence you in this case for committing, or could sentence you to an additional period of 1 year, whatever time is left on 3 years of post-release control, for committing that new offense while you're under post-release control for these cases. And if that occurs, that has to be served consecutively with the sentence in the case. You're also ordered to pay the court costs for judgment, grant, execution order. If you fail to do that, then the clerk can collect that through various means, including levied on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, the court will order you to community service and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until. All right. Is there anything further from counsel?
No, Your Honor.
All right. You're advanced to custody, Mr. Butler.
We doing Sauer, Willis, Your Honor.
Who do you have out there? Swords?
I have Mr. Willis for the Raymond, and I think we moved Sowers up till today.
Okay, yeah, let's do Mr. Willis, please. Willis, please. Yeah. All right, this case number 22 CR 006, State of Ohio versus Harold H. Willis. You are Harold H. Willis, appearing from the jail. All right, Mr. Willis was indicted on 4 counts of rape on 1st of February, and the court was going to do a arraignment last week, and then he indicated he was in the process of hiring counsel and wished to wait till he was able to do that. And I had a bail review hearing Friday, and he was still not represented, so I just left things as they were. Now, my understanding is, Mr. Wagner, you're going to represent the defendant, personal employment?
Yes, sir.
All right. Do you wish to have the indictment read?
Yes, sir. We are not guilty of all counts, Your Honor, and waiting for reading the indictment.
All right. All right, let's see here. When was the defendant arrested? When?
December, Your Honor.
December what?
29th, I believe.
Okay, that looks up for me. All right, well, Mr. Wagner, that puts us on a pretty tight leash as far as, the speedy trial is concerned, so I'll have to put this up very quick schedule. First pre-trial will be February.
I apologize, Your Honor.
Okay.
If I may, due to the formality, you may want a more proper, paper trail, but I've already discussed the trial with my client, and we are willing to waive that. If you want a signature from him, I'll get a formal paper trail on that, Your Honor.
All right, well, I would have you sign a written waiver, but I'll go ahead and do it orally then on record here. Mr. Willis, under the law, a person who is charged with a crime has a right to have their trial completed within 270 days of the date of their arrest, which would be 270 from December 29th. Now, if that person is being held in jail on that charge, in that case only, as it appears you are here, then each day that you spend in jail counts as 3. So that means it's 90 days. And my calculation at this point is that would be March 28th. Now, you can agree to waive that speedy trial time. And waive means to give up. And if you do that, that means that the trial will be extended beyond that because 28, today's like 14, so you got 14 days left in February and 28 in March, so that's 42 days. And my last trial date in March is March 24th. So that'd be 38 days. That's only a little over 5 weeks. It's a pretty quick turnaround for any kind of criminal case, let alone one that's got 4 rape charges. Actually, there's 7 rape charges in it. I was just looking on the first on the one side. And so, and those I think would carry possibility, some of them would carry possibility of life involved. So, if you're willing to give up your right to have your case tried by the 28th of March, or start at least, it has to start and then finish, start at that time, then I will give, I'll probably give a schedule that will give us a trial date probably in early May, so that your attorney will have more time, as well as you, to work on getting this case ready for you to do the thing. Now, do you understand that?
Yes, sir.
And are you in agreement with waiving your speedy trial limit of 90 days and agreeing to have it continued to trial date in May?
Yes,
Okay.
sir.
All right. Well, I would ask that you sign a written waiver that Mr. Wagner will get one for you. All right. Well, the court will find then, make a finding that the defendant waived the speedy trial time. Under 2945.71. And so therefore, the court will set this for a first pretrial on March the 2nd at 1 p.m. and that'll be by Zoom. Final pretrial will be April 13. I tell you what, I think we're fairly busy on the 2nd, so I'm going to move it back to the 16th. Yeah, the 16th instead of the 2nd at 1 o'clock. April 13th will be the second pretrial at 1 o'clock. And then the jury trial will be set for May 9 at 8 a.m. All right, now, Mr. Wagner, you wish to be heard in the matter of bond.
Only Your Honor, giving my client in the past, since Friday really, been in contact with my wife multiple times. Actually, other individuals have reached out to me, so not so about the case. What I'm trying to demonstrate, Your Honor, is clear contact with this community. Would ask the court to consider bond, very serious nature of offense, and the state's going to have a problem with that. But again, anything that can help him aid in his defense, Your Honor, in the amount and from my office, helping him collect evidence, things of that nature, Your Honor, any reduction would be appreciated.
For King, on behalf of the state.
Thank you, Your Honor. The state would ask that bond be set at $500,000. This defendant is facing 7 counts of rape. 3 of these counts, the victim is alleged to be under the age of 10, which would carry a sentence of life without parole or convicted. So based on that, the state position of $500,000 bond would be appropriate. Thank you.
Am I reading correctly that there's allegedly 3 separate victims?
Yes, Your Honor.
Or maybe 4. I see count 1, it's K-E, F, and I-W. In count 3, there's an I-W and a J-M. So that would be 3, and then in count 7, there's a K-A-F. So are there 3 or 4?
4.
4, okay. All right. Anything else, Mr. Wagner?
No, sir.
I'll set the bond in the amount of $250,000 plus OR, which is the promise to appear, to fail to appear, you can be prosecuted for additional felony. Mr. Willis, we do make bond. We'll be required to pay a deposit of $116 for certain statutorily formally required service fees prior to release. You make bond, we have a pre-trial supervision probation department at 117 East Main Street. We require to report there, being on release, and then once 4 weeks after that is they determine that we ran a drug test and may order provide donors for home to sell employer, no contact with any of the alleged victims, recommended by probation, evaluated substance abuse, mental health issues, and treatment indicated to enroll in and follow that during administrative action. We'll also be under house arrest. The residence meeting has to be there all the time, unless you're working or doing some work. Medical appointments, court proceedings, in this or any other case. Appointments with an attorney or probation officer in this or any other case. Attend any kind of job training, educational programming of any type, or church services, otherwise you have to be there all the time. What would your address be if you were released, Mr. Willis?
203A South 2nd Street, Greenville, Ohio.
That's not the residence of any of the alleged victims, is it, Mr. King? Alright, so you'll have to be there all the time, and if you fail, other than as I explained, and if you fail to provide, court then could revoke that and hold you till further court. Alright, anything further then, for this case? Alright, and if you bring in Dustin Sowers, officer, please. And Dennis Klein is in the jail, right? Okay, Mr. Wright. All right, this is case number 21 CR 86, State of Ohio versus Dustin L. Sowers. And are you Dustin L. Sowers at the jail with Mr. Wagner? All right, Sowers is charged with aggravated trafficking, methamphetamine, and aggravated possession. The pre-trial was set for Wednesday, but was moved up to this afternoon at the request of counsel. Is discovery complete in this case, counsel?
It is from the state, Your Honor.
Wagner, have you filed yours yet?
I believe it is, Your Honor, correct me if I'm wrong, this is one that's kind of been lingering around since, middle of 2021, correct?
Been lingering because he was not before the court.
Yes, I didn't mean it that way, I apologize, sir, but, I'm going through my file, making some my files, thing.
Yeah, you complied, Mr. Wagner.
Okay. There are no pretrial motions, I don't believe.
Nope.
And is your client aware of the plea agreement?
Yes, I think if I can get back out there with him for the past half hour and get back up to the prosecutor's office, and maybe having a resolution setting this thing for a plea date.
All right. Okay, anything else needs to be discussed?
Yes, sir.
All right, thank you. All right, then we'll need Jacob Wright from the jail, please. Be Mr. Kirk's client.
If I may have just a second, Your Honor, I don't have this file, I gotta go grab it.
All right. This is just an arraignment.
Okay. Most recent.
All right, case number 22 CR 35, State of Ohio versus Jacob R. Wright. You're Jacob R. Wright, appearing there at the jail.
Yes, sir.
All right, Mr. Wright, you were indicted by the grand jury on February the 1st on 2 counts of aggravated trafficking of methamphetamine, 2 counts of aggravated possession, 4 degree felonies. And I see that you did fill out a financial disclosure form. Everything on that form is correct.
Yes, sir.
All right. The court will appoint Mr. Kirk, who was present for this hearing, as he represented you in your other case. And Mr. Kirk, have you had a chance to look into the charges?
I do have a copy of the indictment that I've taken from the clerk, Your Honor.
All right. And
We
go ahead.
would waive reading of the indictment and then enter a plea of not guilty to all counts.
All right. The court then will set a pre-trial on this case for March the 16th at 2:00 p.m. What's this? Final pre-trial will be April 13th at 2:00 p.m. Trial date will be April 28th at 8 a.m. All right. Now, state requesting a bond of $15,000. Is that correct, Mr. Kirk? Or Mr. King?
That's correct, Your Honor.
All right, Mr. Kirk, you wish to be heard on the matter, Dale?
Yes, Your Honor, thank you. In this case, would ask the court to OR my client. He has been at the counseling center since he was sentenced by this court back in January on his other case. I have a letter from the counseling center states he's been a model client. He's participated very actively. He's been making significant progress in his goals for treatment. And I note that the charges in the indictment stem back from June of 2021. So when we did sentencing back in January of this year, the state would have been aware of this case, and it was not brought until the February grand jury. So in this case, he has been in counseling. It's been successful. He's cooperated with the probation department when they took him into custody. There were no issues. And we put a lot of resources into this so far, and we just asked the court to consider that in setting a bond. And again, no R bond if possible, so he can return to the counseling center. It's my understanding they'll accept him back immediately. They've even offered to come get him and transport him back so that he can continue in treatment.
Is that correct, Ms. Sturgill? Okay. All right. Well, I'm going to go ahead and grant the OR only bond on condition that, you'll be under pretrial supervision probation department, so you're gonna have to be checking in with them. That would be a different, officer other than the drug court. You'll be required to, report to them once a week for 4 weeks, and after that, as a determined that we're in drug testing, might be ordered by phone numbers from all self-employer. You'll have to, remain in the, residential treatment program at the counseling center. How long have you been down there, Ms. Virgil?
Just about a month, I believe.
Okay. So the big condition on you remaining in that. And if you fail to comply with those conditions, then, the court could, revoke this bond and order you to be held until further report. All right? You have any questions, Mr. Ryan?
Well, I'll be going to treatment today, or?
I don't know, whenever they come get you. So you'll be held until the treatment center picks you up. You're not gonna, I'm not gonna turn you loose, go back to